Privileged to have this opportunity to invite Honorable Retired Justice of Allahabad High Court, Sri Sakharam Yadav Singh, Singh Yadav, in the orientation program 2021. During his tenure as High Court judge from 1991 to 2002, Sir has delivered many landmark judgments on issues involving the upliftment of weaker sections of society. Sir was Vice Chairman of Central Administrative Tribunal Additional Bench, Bangalore till 2005. Since 2005, Sir has been practicing law in Supreme Court as senior advocate. Sir was also a member of the search committee of the first Lokpal of India. Presently, Sir is a member of Executive Council Vishwabharati Shanti Niketan, West Bengal, and a member of Executive Council Mahatma Gandhi Kashi Vidyapeeth, Varanasi. Not taking much time because the list is long. Now, I would request, Sir, please start the session and enlighten us with your valuable knowledge, sir. Please, sir.
Professor Ranjit Singh ji, Professor Dr. Nitesh Purohit ji, Dr. Vibha ji, and my young friends who are the future of India. I am grateful to you for inviting me to this orientation camp on the subject Constitution, or Introduction to Constitution. But before I come to the Constitution of India, I would like to interact with you with the Constitution or the law that was governing the country prior to the Constitution coming into force. As you know, East India Company rule was known as Company Rule between 1773 to 1858. There, the Regulating Act 1773, under this act, Bengal, Governor of Bengal was designated as first Governor General, and Lord Warren Hastings was the first Governor General. Then came Pitt India Act. Pitt India Act was named after the name of William Pitt, who was the British Prime Minister at that time. Under this act, Pitt India Act 1784, it rectified certain defects in the Regulating Act 1773, and Parliament passed the Amending Act, also known as Act of Settlement. Important features of this act distinguish between commercial and political functions of the company. And then companies' territories in India were called British possession. British government was given the supreme control over the company's affairs. Then next act came into force, Charter Act 1883. Under this, mode of Governor General of Bengal as Governor General of William Bartik, first Governor General of India. Thereafter, you know, the Governor General of India was given exclusive legislative power for the entire India, entire British India. Attempt was made to open system competition for selection of civil servants. It was under this act that open competition was introduced. Then came Charter Act of 1853. The essential features of this act introduced open competition or maintained open competition system of selection and recruitment of civil servants. It was introduced by the Macaulay Committee in 1854. First time separated legislative and executive functions of the Governor General Council. It provided for addition of 6 new members called legislative councillors in the council. Then, it was under this act, it introduced first time local representative in Indian Council. I mean, the Indian people were allowed. 6 members were appointed by local government of modern, what is Madras, Bombay, Bengal. Then the Government of India Act 1858, also known as Act for Good Government of India. It abolished the East India Company. East India Company was abolished under this act, Government of India Act 1858. And powers of government territories and British Crown changed the designation of Governor General of India to Viceroy. It was under this act the Governor General of India name was changed to Viceroy. Then legally confined improvement of administrative machinery by which the Indian court was to be supervised and controlled in England. Lord Canning became the first Viceroy of India. Then came the Indian Council Act 1861. It is an important landmark in the constitutional and political history of India. Its main features are the representative institutions of associating Indians with the lawmaking. It was for the first time the Indians were associated with the lawmaking process. It was this act which provided that Viceroy should nominate some Indians as non-official members of his council. And it was under this act established three new legislative councils for Bengal, Northwest provinces, and Punjab. Then Indian Council Act 1892 came into force, and it enlarged the size of functions of the central and provincial council, increased the functions of legislative councils, and gave them the power of discussing budget and addressing questions of the executive. Then Indian Council Act 1901 came into force. It is also known as Macaulay-Parley-Binto reforms. Lord Marley was the secretary and Lord Minto was the viceroy. Main feature is it provided for association of Indians with the executive council of the viceroy and governors. It also provided separate electorate to Muslims. The divide and rule policy began with this. Muslims introduced system of communal representation. Lord Minto was known as father of communal electorate. Then came the Government of India Act 1919. It relaxed the central control over the provinces by demarcating and separating the central and provincial subjects. It also divided subjects into two parts: transferred reserved subjects. Transferred subjects were to be administered by the governors with the aid of ministers responsible. The reserved subjects were there. The Simon Commission 1927 was the outcome of Pitt. Rowlatt Act authorized government to imprison any person without trial. This was a very dangerous thing. Rowlatt Act authorized government to imprison any person without trial and conviction in a court of law. This was intended to stop towards complete responsible government. Then came the Government of India Act 1935. This was the Government of India Act. It was repealed for the first time by the Constitution of India, Article 395 of the Constitution of India. It was second milestone towards completely responsible government. It provided for establishment of all Indian federation consisting of provinces and princely states as units. The act divided the powers between center and units in terms of three lists, just as in our constitution also there is the central union list, state list and concurrent list. It was under this Government of India Act 1935 that three lists, legislative lists were divided. For center within 59 items, provincial lists contain and 54 items, concurrent lists for both union and states. Separate electorate for it also provided for separate electorate for depressed classes. Influence of scheduled caste, scheduled tribes, they recognized their force, and it was under this act, this 1935 act, separate electorate for depressed classes, women, laborers. It extended the franchise move, then 10% of total population got voting right. Then it was under this act, 1935 act, that Reserve Bank of India was established for the first time. 1st April 1935, the Reserve Bank of India came into existence. It provided for establishment of not only Federal Public Service Commission, but also Provincial Public Service Commission and a Joint Public Service Commission. Today we have only two commissions, Public Service, State Public Service Commission and Union Public Service Commission. But under the 1935 Act, there were three commissions, one Federal Public Service Commission, second Provincial Public Service Commission, and third Joint Public Service Commission. And it also provided for Federal Court, which was set up in 1937. Then came Indian Independence Act 1947. World War II, as you know, was between 1939 to 1945. The British indulgence in it, which weakened Britain economy. Rule of INA outside India as well as in India. Quit India movement started by Gandhiji in 1942. Cabinet Mission Plan 1946, which provided for making of Constituent Assembly. It was under this Indian Independence Act that there was a provision for providing a Constituent Assembly. Revolt in Indian Navy, and it was during this period, ended British rule. It was under this act the British rule was ended and declared India as an independent sovereign state from 15th August 1947. Act provided for creation of two independent dominions, India and Pakistan. Abolished post of Secretary of State of India, the Governor General and provincial governors to act constitution head. It discontinued the appointment of civil servants and reservation of posts by Secretary of State of India. It empowered the Constituent Assembly of two dominions to frame and adopt any constitution for their respective nations and to repeal any act ceased to be the source of authority. Then, as you know, the Constitution Assembly was Constituent Assembly was constituted. idea of Constituent Assembly for India was put forward for first time by M.N. Roy in 1934. And in 1935, Indian National Congress for the first time officially demanded a Constituent Assembly to frame the Constitution of India. Demand was accepted in principle by British government in August 1940, and in April and in 1942, Sir Stafford Cripps came to India with draft proposal. Cripps' proposal was rejected by the Muslim League. Then the Constituent Assembly, as you know, what is that letter? Dr. Mr. Sinha. Mr. Sinha was the senior most member of the Constituent Assembly. The first meeting, Mr. Sinha was Sachidanand Sinha. He was appointed as the president of the Constituent Assembly in order to administer oath to other members. After the oath was administered to other members, Dr. Rajendra Prasad became the president of the Constituent Assembly. And that assembly appointed Dr. Bhim Rao Ambedkar as chairman of the drafting committee. Constitution was drafted by that committee, and then, as you know, drafting committee had 7 members: Aladi Krishnaswamy Iyer, N. Gopalaswamy, B.R. Ambedkar as chairman, K.M. Munshi, Kanhaiyalal Malikar Munshi, Muhammad Sadaullah, B.L. Mittal, D.P. Khaitan. And the first meeting on 30th August, drafting committee elected Dr. Bhim Rao Ambedkar as its chairman. Towards the end of October 1947, the drafting committee began to scrutinize the draft constitution prepared by B.N. Rao, the constitutional advisor. It made various changes and submitted the draft constitution to the President of the Constituent Assembly, Dr. Rajendra Prasad, on 21st February 1948. The drafting committee and its members were very influential in Indian constitution making. During the committee stages, all the deliberations of the Constituent Assembly, majority of the debates in Constituent Assembly revolved around the draft constitution prepared by drafting committee. Out of 166 sittings of the Constituent Assembly, 144 were spent debating the draft constitution. And what happened, as you know, the constitution was adopted on 26th of November 1949. And it is we, the people of India, who have given the constitution to the India. The preamble to the constitution, which was adopted along with the constitution, represents the values that are incorporated in the constitution. And the word says, we, the people of India, adopt, enact, and give to ourselves. It's not an outsider. We, the people of India, and give to ourselves this constitution, declares that the constitution emanates from the people of India, and that the constitution rests on solely their authority. The use of this phrase is deliberate in order to sufficiently clarify that the Constitution of India, unlike previous legislations governing the country, were not a product of British Parliament or any outside agency. The word "we the people" is not just a historical statement for fact, it is continuing statement including all the people and imposing upon them a duty to abide by the principles sought to be achieved by the Constitution. The influence of the American Constitution is visible in the preamble itself. In both the place the authority constitution making in the hands we the people. In the American Constitution and also the Indian Constitution, the authority to make the Constitution is we the people. The preamble embraced the aspirations of justice, social, economic, political, embodied in the Russian Constitution, and adopted the ideals of liberty, equality, and fraternity from the Constitution of France in 1791. Sovereign, the word sovereign signifies that the authority of Indian state is independent and that it is not subject to the control of any other state or external authority. The preamble declares in unequivocal terms that the source of all authority are the people of India itself. It is a government by the people and for the people. Modi ji has added a new word, government of the people, for the people, and with the people. Socialist, term socialist, the expression was inserted into the preamble by the Constitution 42nd Amendment 1976. Though the word socialism is vague, the Supreme Court in D.S. Nakara v. Union of India observed that the principal aim of a socialist state is to eliminate inequality in income and status and standards of life. According to Supreme Court, the goal of Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards Gandhian socialism. The Indian Constitution, therefore, does not seek to abolish private property altogether, but aims at offering equal opportunity to all. Then the word secular is there in the preamble. Secular, while this expression too was formally inserted into the preamble by the 42nd Amendment, it was never doubted that the Constitution established a secular and not a theoretic state. Professor K.T. Shah, a member of the Constituent Assembly, had proposed to add secular to the preamble. However, some members, including B.R. Ambedkar, felt that it would be unnecessary given in the Constitution embodies the values of secularism via Article 25, 26, and 27. But the secular was subsequently added by the Constitution Amendment. The Supreme Court in S.R. Bomai versus Union of India recognized secularism to be a part of basic structure of the Constitution, not amenable to any amendment. Then the word democratic occurring in the preamble, it envisages a parliamentary democracy wherein there is a representation of the people, responsible government, and accountability of the Council of Ministers. Then republic signifies that in contrast to the constitutional monarchy, where the head of the state is a dynastic position, we have an elected president as the head of the state, and offices, including that of the president, will be open to all citizens. In the case of Berubari Union, the Supreme Court clarified that though by itself the preamble is not enforceable in the court of law, it can nevertheless be used to aid the legal interpretation of the Constitution where the language is found to be ambiguous or are capable of two meanings. The court also observed that one of the essential attributes of sovereignty is the power to cede parts of national territory if necessary. On this basis, the court came to the conclusion that since the preamble is not a part of the Constitution, it is not enforceable in court of law and thus would not impose any limitation on a nation's right to cede its territory. This view did not find currency when the Supreme Court sat down to deliberate this question in Kesavanand Bharati versus State of Kerala, differing from the opinion expressed in Berubari. For the first time, a bench of 13 judges assembled and sat in its original jurisdiction, hearing the writ petition. 13 judges placed on record 11 separate opinions to the extent necessary for the purpose of the preamble. It be safely concluded that the majority of Keshavanand Bharti case leans in favor of holding, number one, that the preamble to the Constitution is a part of the Constitution. Number two, that the preamble is not a source of power nor a source of limitation, prohibition. The third, the preamble has a significant role to play in the interpretation of statutes, also in the interpretation of provisions of the Constitution. As you know, the preamble provides significant help in the interpretation of the Constitution when words actually are ambiguous. Under such circumstances, it is the key to open the minds of the makers of the Act. But if the language of the article is sufficiently clear, it is not to be interpreted in the light of preamble in preference to the obvious meaning thereof. The objectives in the preamble are just a part of the basic structure of the Constitution and nothing more than that. So preamble cannot be amended so as to destroy the objectives, but also cannot be used as a law to judge people. Now we have our Constitution, as you know, is the lengthiest written Constitution. इसके, as you see, United States, America, fundamental rights, independence of judiciary, judicial review, impeachment of president and Supreme Court judges and High Court judges. United Kingdom, that is provided in United States, America. So is the provision in the Indian Constitution also. And in the United Kingdom, single citizenship is there, parliamentary system of government, rule of law is there. Whereas in Canada, quasi-federal government system, appointment of governors. Australian Constitution provides for concurrent list, joint sitting of two houses of the parliament, freedom of trade, USSR, and fundamental duties. And we have fundamental duties introduced. It was not a part of the Constitution, it was introduced by amendment in 1976. Fundamental duties are though not enforceable in law, but somebody has recently filed a writ petition for a direction that it should be enforced. If the fundamental duties are enforced, then many problems that we are facing that may go. People don't observe their duties, they just fight for rights. See, the Constitution, the part 1 provides for unions and its territory. Part 2, it is in about 22 parts. Part 1 contemplates of unions and its territory. Citizenship, part 2. Then fundamental right in part 3 of the Constitution. 6 fundamental rights which are as follows: the right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Remedies are Article 32 and Article 226 of the Constitution. These are the fundamental rights, they cannot be taken away. Part 4 of the Constitution of India, Article 36 to 30, contains the directive principles of state policy. It directs the state to follow its policy in accordance with the principle contained in the preamble of the Constitution, to eliminate inequality, to avoid concentration of wealth in few hands. All these are things in the directive principles of state policy. Government has to follow those policies. Article 37 clearly states Indian Constitution about the application of the directive principles. These principles aim at ensuring socio-economic justice to the people and establishing India as a welfare state. It was on the basis of this article that you can say that our is the welfare state. And then to abide by the Constitution and respect its ideals, and institutions the national flag and national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty. These are all fundamental duties. To promote harmony and a spirit of common brotherhood amongst all the people of India, transcending religion, linguistic, regional or sectional diversity, to renounce practices derogatory to the dignity of women, to value and preserve rich heritage of our composite culture. यहाँ अनेकता में एकता है भारत में, इसलिए ये फंडामेंटल ड्यूटी के चैप्टर में आया है. To value and preserve the rich heritage of our composite culture, protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher values, levels of endeavor and achievement. And as you know, we are heading towards artificial intelligence. Your institution, Indian Institute of Technology and Information, that can play a vital role in the artificial intelligence, which according to experts means when the machine is capable of taking decision like human being, that is known as artificial intelligence. And the future of India, sitting in front of me, these young students, they, I believe, are capable of providing such a artificial intelligence which may be preserve the Indian culture, Indian heritage, and all these things can be done if emotional integration is not disturbed. Country, we have all caste, all religion, all sorts of things are there. So responsibility lies on the young and future India sitting in front of me. They have to do a lot of duty, perform a lot of duty, lot of burden on them to see that India prospers and fulfills the ambitions of everybody, every person. That this inequality in status should be abolished altogether. It's not that 1%. That is why you see we have single vote, but the president vote is same value which everybody commoner vote is there. That is the value of our constitution. So these words I am thankful to my friend Professor Raj Singh, Rohit ji, and Bibaji for giving me this opportunity to interact with the future of India. And thank you very much, thankful to very much. Thank you all. I think I finished it before time.
Thank you, sir. Thank you. So, student, okay, what happens? What happens? Am I audible?
Yes, you are audible.
Yes, you are audible. Any question? We have just listened to a very important talk from Justice Sakharam Singh Yadav, sir. So, anything, if you have any question, any query, any clarification, please feel free to ask. We have still a few minutes left.
Everybody left.
Okay, so I think Okay, so I think they do not have any questions. So, Madam Vibha,
do not have any questions. So, Madam
I request Vibha Madam to please convey the vote of thanks. And thank you, sir.
convey the vote of
Personally, I'm extending my gratitude to you for accepting our invitation.
No, you need not express any gratitude. In fact, I should express gratitude to all of you for giving me an opportunity to interact with the young and future of India. Thank you.
Vibha ma'am, please.
Thank you, sir. I think this is the first time our students are listening about constitution and all, because they all are science students, so they would not be much aware about the constitution. So definitely that is the first time they would be listening about their fundamental rights and duties as a good citizen. So on behalf of all the students, faculty members and other members of the institute, I, Dr. Vibha Yadav, would like to extend my heartfelt thanks to Honorable Justice Shri Sakha Ram Singh Yadav for giving us such insightful information and knowledge on establishment of Indian Constitution and making us aware about our fundamental rights and duties as a good citizen of India. Thank you, sir. Thank you so much, sir.
Thank you. Thank you.
Thank you, sir.
Okay, so students, this is the only class for today. So there is no class. The orientation camp for today. Again, we shall be meeting at 11 o'clock. 11 o'clock, I repeat, tomorrow. 11 o'clock, Professor Alok Tripathi on Indian heritage. And remember, Professor Alok Tripathi is director of Archaeological Survey of India. He is a very renowned speaker, very good orator. So don't miss his classes. We definitely have a lot of things to listen to. Tomorrow we shall be assembling here once again at 11 o'clock. And then bye-bye.